When I refer to the SMS speech just now, she said that MOM will take employer to task for not following the fair consideration framework. I would like to seek clarification from the SMS in what way employers will be taken to task, and secondly, how many employers have been taken to task thus far? And the other clarification was on the job ban. I would like to know, when a company has a job vacancy, if the company consider the vacancy as an internal transfer, do they need to follow the framework to advertise on job bank? Because I understand that it has become like a loophole where you consider internal transfer and you don't advertise, but you get a transfer from another branch in other country to fill the vacancy, instead of advertising to have on a job bank to allow Singaporean to apply. Thank you.
Regarding the action that we will take for firms that we find have engaged in discriminatory practices, you also asked for the numbers. Actually, I gave it in the reply, I think, in response to Mr. Zaki Muhammad's query. There were a total of 230 nationally related discriminatory complaints that was received either by TAFED or MOM in 2014, and that was actually down from 310 in 2013. So basically what we do is when we receive the complaint, we'll assess and study the information provided by the complainant. Of the 230 complaints that we received, about 40% were unsubstantiated, right? There were some of the reasons are there were actually complainants who, when we pursue, they refused to provide further details, including their own names. For those where the allegations are substantiated, the case officer would engage the company to learn about, what are the issues and so on. So there are various recourse and various actions that we take. For those that is just HR gaps, we will then advise them and get them to plug the gaps and follow up. For those that are more serious, we may issue warnings. We will also put them on a tighter scrutiny. And there will also be some where we may curb their work pass privileges. So about a third of the cases, there were issues, and we either issue warning, put them on scrutiny, or curb their work pass privileges. Right. Regarding the intercorporate transfers, these are actually exempted from advertisement requirement. You know that we are a global and regional business hub, so companies that are based here, headquarters here, will need to transfer some of their senior personnel and office professionals here because they want to understand the market or to lend their expertise and experience. In fact, actually, our own firms do the same thing when we venture abroad. And they also send locals overseas. So we allow exemption, but it's actually very stringent. In order to allow exemptions, the definition of ICTs must comply with WTO's definition under the General Agreement for Services. So there are certain criteria that they must conform to. We actually implement this very stringently. We look at the salary, look at the organizational chart to see if they actually conform with the ICT definition before they are allowed to enter. And there are actually limits as to the length of period they are able to stay here. But we need to allow this simply because, like I say, we have got regional and global business hubs. And since we implemented Jobs Bank, actually about half of the applications, the ICT applications, have not been approved, have been rejected. So the conditions are stringent, and we study every case carefully.